Hi, today's topic is High Court deception. Imagine preparing to go into a High Court hearing as an expert witness on business valuation matters when you know without a doubt you are not qualified. If you are not qualified, why lie? Now, the case I'm about to talk about, they knew in advance that this case was about tangible assets versus intangible assets. Now, before you react to what I'm about to, what you are about to see and hear, I recommend you consider all the facts before jumping to conclusions. I am a qualified valuer and accountant, and I aim to expose what I see as a habit that will damage the credibility of the accounting industry in future years. If you are not an expert in a particular subject, choose truth over a lie. If you disagree with what is presented, you can form an argument to the contrary. Please do so. If not, change. The accounting industry know absolutely nothing about business valuation matters. And all I ask is that they be truthful with their clients and the law. The latest High Court case will show how they have misrepresented themselves. Not only have they fooled the courts, but they have fooled Crown Law departments for decades, because there is none bright enough to detect the shortcomings in their methodologies. The High Court has, in Placer-Dome case, Inc., 2018. And the High Court justices in this matter should be commended for their incredible acumen and insight to reject accounting reports and methodologies as unreliable. The methodologies used by accountants and most business brokers are old, antiquated, and have been rejected by the law, and they cannot keep pace with modern day businesses and are not based on market movements, and they create massive legal implications for those that use them or the recipients that follow their advice. They are not valuers, yet they call their report valuations. This is a blatant lie. Expert witnesses must be experts in their field, otherwise they are not experts. And the requirements of the court are quite specific. What is required of an expert? Not to mention the professional standards that they should operate under. Expert witness requirements for the Supreme Court, which is a far lower court than the High Court. The expert must make it clear when a particular question or issue falls outside his or her field of expertise. They fail this statement all the time. They cannot escape any of their past reports. The general duty to the court. I won't read this all out, but I'll read some of it. The expert witness has an overriding duty to assist the court on matters relevant to the expert's area of expertise. Well, accountants are not valuers. They fail this requirement all the time. Then, an expert witness is not to be an advocate of the party. Well, they're not anyway. The expert witness's paramount duty is to the court and not to the person retaining the expert. The form of expert evidence, and this is where we get to this situation about qualifications. The expert's written report must give details of an expert's qualification and of the literature or other material used in making the report. All assumptions by the expert should be clearly and fully stated. The report should identify who carried out any tests or experiments upon which the expert relied in compiling the report, and give details of the qualifications of the person who carried out such test or experiment. Where several opinions are provided, an expert should summarise them. Qualifications are an overriding element of being an expert. And secondly, none of the market evidence can be found in any expert's report relating to business. But if it is supplied, it is always lacking in relevance as evidence due to time, distance or applicability to the subject business or property. At the end of the report, the expert should declare that he has made all inquiries which he believes, or he or she, are desirable and appropriate, and no matters of significance which the expert records as relevant has been withheld from the court. Well, again, they fail this every time. Market evidence is never supplied or is spasmodic. Accountants use this equation in their reports with some variations, but based on the same insane premise that it all comes down to risk and return scenarios. This is the equations on your screen. Now, here it is. It is here you can disprove their reports and have them thrown out of court as non-experts in business valuation matters because their reports are false, misleading, and not based on valuation techniques or the markets. The legal case history, Muller's case of 1901, or their reports are not based on market information. Make them prove where they got those numbers from that's in the equation, and always ask for tangible asset valuation inventories. You not only want the valuation, you want the list. Never use or accept written down values contained in financials. They are a taxation concept and have absolutely nothing to do with current market values, full stop. All businesses have many components or assets, and all must be valued as at the date of valuation. There are tangible assets and intangible assets that must be itemised and tabulated in a graphic format with supporting photographic evidence that indicate or provide evidence of fieldwork and research based on market investigations that is indisputable. Not the result, just that the works have been, or what works have been involved to produce a result. Results are open to interpretation. Valuations generally are reliable unless participants have exercised bias in their reporting by manipulating market evidence or choosing sales that best suit their requirements, or the selection of comparables that seem the same but are in fact misleading. If you are valuing a converted office building, you cannot choose designated single-use comparables as evidence. You must value on unimproved state, not tenants' improvements. It is net profit. It is not net profits or false returns that create value. It is market transactions that prove value. The golden rule in valuation: if you cannot prove it, don't use it. This rule is unknown to the accounting industry. Accounting tries to fool the legal profession by providing reports based on financials alone, and they have been highly successful until now. The High Court of Australia, in Placidome Inc. case of 2018, has finally recognised the blatant stupidity of accounting methodologies to provide accurate information that can assist the court to determine values with certainty. None of this will stop them. But where is the truth? Where are the ethics? Where are the professional standards? You won't find them anywhere. They keep using false, old methodologies that have been rejected by the highest court in the land. One day they will have to face the truth. They are not qualified. The interpretation of financials will never be able to predict values. So if you do not wish to be fooled or your clients misled, always ask for two valuations: a tangible asset valuation and an intangible asset valuation. The accounting industry cannot provide these. They are not trained in valuation, nor can they call their reports valuations. For all involved in dispute resolution, if you cannot provide graphic evidence of all asset values, you are misleading and cheating your clients. It is not only the accounting industry, but most business brokers that use this rubbish and do not have a clue, and place their clients in legal jeopardy by using such stupid methods. Accounting methodologies are no longer relevant in this dynamic, highly variant commercial world today. The High Court of Australia has rejected them. The world's commercial markets have moved away from them, and you should too. If you cannot value business assets every day of the week and record them in a graphic format, you should get out of the game. Which means that waiting for financials indicates you know nothing about business assets or markets. And only those valuers that can complete this sheet in a graphic format truly know how to value all assets at any time and do not have to wait for the preparation of misleading financials. It is clear from the High Court case in Placer-Doming that accountants could not specify tangible asset values or intangible asset values, which means they are unable to complete this worksheet. Their efforts using the income approach and discounted cash flow fell well short of believability. Discounted cash flow was rejected because they could not predict future values with certainty. You will never prove values by trying to predict the future. You must know values today. Then they tried the balance sheet approaches of top down, bottom up. Here is more proof that they do not know what they are doing. They claim if you know the value of one, you can subtract it or add it to predict the other. Serious? What? This is High Court. What utter stupidity! What deception! Trying to convince the High Court without valuation qualifications. They should be made to compensate their clients. They were not valuers. They were not qualified. Therefore, they fail the expert witness test. And you can never get true values from financials. The High Court has spoken. The rubbish contained in accounting reports has been rejected as being unreliable. The lie has been detected. Never trust another accounting report claiming to be a valuation. In fact, if you have suffered a loss due to such a report, you should sue. They were not able to prove the value of either asset, tangible or intangible, using financials. Financials record what happened in the marketplace. They are useless in predicting market values. What does it take for so-called professionals to stop lying and misrepresenting the truth to courts? By the way, in fact, if you have suffered loss due to such a report, you should sue. That concludes today's presentation. I hope you get your copy of my book soon. Thanks for watching.